This program is sponsored by Tilson Solicitors.
Assalamu alaikum, hello and welcome to another episode of the Legal Forum, here only on the Islam channel with me, Lee Clark. Now, as you may be familiar by now, each week we discuss common topics in layman terms to help guide you with legal advice. Breaking down the complex language of law, the Legal Forum invites expert solicitors to the show to hear their viewpoints on the topic being discussed. Now, as always, we must stress that the views and opinions expressed in Legal Forum should be considered for informational purposes only and not case-specific legal advice. All topics are discussed in a generic nature, and it's important that you consult either with a CAB, law centre or a solicitor before relying on it. Now, following from our first episode on Islamic wills, today we look at inheritance tax. Inheritance tax is a tax on the estate which includes either property, money or possessions of someone who has died. To discuss this topic further, I'd like to welcome back Shakil Bakari Shah to the show and explore how you can deal with these situations whilst you're alive. Shakil, welcome back to the show.
Thank you for having me
again.
Nice
to see you.
Thank you.
Now, this is obviously probably a complex nature. What is inheritance tax?
Inheritance tax is a tax that's paid on a deceased person's estate where his estate is worth more than $325,000. The $325,000 is considered the nil rate band or the inheritance tax threshold. So therefore, for example, if I die and my estate is worth £425,000, then you take away the nil rate band, the $325,000, and the $100,000 that's left is taxed at 40%, which means that my executors will have to pay £40,000 to HMRC.
Now, I should imagine this is a particular sore thing, a subject for people to actually have to pay all this money to tax. Obviously, it is the law. Is there any way that you can minimise the tax that you need to pay on inheritance tax?
Well, there's steps you can take to minimise inheritance tax whilst you're alive and also on death. There is a slight difference between Islamic wills and English wills. An English will allows you to minimise inheritance tax by using exemption, gift allowance, potentially exempt transfers, and the spouse exemption, which really is the most important. If I can explain, a spouse exemption in English law means that where a spouse dies, his partner does not have to pay any inheritance tax on anything that is bequeathed to her. Also, under English law, any lifetime gifts made by your spouse is free from inheritance tax. So where a millionaire, for instance, dies, if he leaves everything to his wife, there is no inheritance tax to pay. Another advantage is that any inheritance tax which is not used by the death of the first spouse can be inherited by the second spouse. So therefore, the $325,000 which is not used from the first spouse's death is added to the second spouse. And when they die, the estate is $650,000, and anything above that, inheritance tax is payable. There's one other. I don't want to make this complicated, but there is something which is called a nil rate band, where a person leaves a property to his children or grandchildren. Then you can use the residence nil rate band. And that at the moment is worth £150,000, but due to change in April in 2020 to 175. That can also be inherited by the second spouse after the death of the first spouse. So if we have a look at it in a simple example, $325,000 plus if any death after April 2020, the residence nil rate band being 175 comes to $500,000. That can then get inherited by the second spouse, and when the second spouse dies, their $500,000 residence nil rate band and their normal nil rate band of $325,000 comes to $500,000. That's £1 million that you can bequeath before inheritance tax is payable under English law. Very different under Islamic law.
Well, I was going to say, a Sharia-compliant will, for instance, and the inheritance tax in that guise, how does it differ then between English law, as you just said?
Well, it differs in a number of ways, but I think I also need to possibly just go off subject slightly in relation to spouses. Now, I mentioned that a spouse can take advantage of their exemptions. You've got to remember that if you're married under Sharia law only, and you've not had a registry office wedding, then under English law, you are deemed to be cohabitating. And if no will is left, and your spouse passes away, then you will not receive anything under the intestacy rule, because cohabitees don't receive anything under the intestacy rule.
So they have no rights to any of those monies at all?
They would have no right. They'll have to make an application to the court as being dependent. So if you are Islamically married, it's best to check that the venue where you were married was registered. And that's quite simple. You can go along to the registry office and just check that. So it's important to get your status correct so you can take advantage of any exemption, because even under Islamic wills, you can take advantage of some spouse exemption. So, sorry. No. If we go back to the difference between an Islamic will, 1/3 you can bequeath to charities or relatives not entitled under the 2/3 rule. 2/3 of your estate has to pass under Islamic law. And that means that where you have, say, for example, a husband and wife, children, and both set of parents are still alive, the wife will only get 1/8 of the estate. Now, if we go into an example, let's just say a person's estate is 700,000. Under English law, if he dies, he can bequeath everything to his wife, and his wife would not have to pay any inheritance tax because it's gone to spouse exemption. Whereas under Islamic law, the wife would get, say, 75,000, add that to the nil rate exemption of 325,000, that's 400,000, leaving 300,000 of the 700,000 estate on which inheritance tax is payable at 40%, which is a lot of money. So you can see that Islamic wills is not as efficient as English wills when it comes to inheritance.
So you can, though, if you do have an Islamic will, you can work it alongside an English legal will to benefit you with the funds that you should rightly have.
Well, you can. I mean, if your estate is below 325,000, then there's no inheritance tax to pay. So an Islamic will would be fine. But if you have an estate that's worth a lot more, with property prices moving up in the last 5-10 years, if you have buy-to-let properties, really, if you're looking to save inheritance tax under Islamic law, you would set up a trust and also take advantage of any lifetime exemptions which are freely allowable in Islam. You can give away as many of your assets whilst alive in Islam without the Sharia rules of inheritance coming into effect. So that's really hopefully what we're going to discuss today.
Yeah. Now, earlier on, right at the very beginning, you mentioned things, opportunities. Gifting was a word that we've heard about this in this subject. What is gifting and how can it benefit you?
Well, there's a number of gifts, allowances that you're allowed that you can reduce your tax. The first one really is your annual gift allowance of £3,000. Now, each individual, that's for each individual. So if you're married, your wife also gets £3,000. If you've not used last year's allowance, you can bring that forward to this year. So this year you will get 6,000 and your wife will get 6,000. And the year afterwards, you will be able to give 3,000 again. So let's look at this into example because it's difficult to actually see how this will work in practice. Let's consider Muhammad and Fatima. They're both 60 years of age. Now, they want to take steps to reduce their inheritance tax, and let's assume for the sake of this discussion that they live to be 80. That's 20 years they can use their gift allowance. If they give their gift allowance of £3,000 per year for 20 years, that comes to 60,000 for Muhammad and 60,000 for his wife. That's 120,000. Bearing in mind that last year allowance they hadn't used, you can bring that forward. So 3,000 for him and 3,000 for his wife will make 126,000 that they will reduce their estate by, which comes to in a region of £40,000 inheritance tax saving you're making whilst you're alive. So, you know, it's a kind of cumulative effect. What will happen is if you use it on a regular basis, you will reduce your inheritance tax so that in 20 years' time, if God willing you live for 20 years, you would have saved quite a lot of money.
Can you backdate it? Say you've had a will in place, but you haven't gifted, or you've forgotten, or haven't been advised to gift up to date. How far can you backdate
1
gifting?
year.
Just 1 year.
Just the 1 year. You can bring forward last year's if you've not used it. Okay. So that's one way of saving inheritance tax whilst you're alive. Another way would be the £250 additional gift allowance. You're allowed to give £250 to any person that you want. If we can go back, I suppose, to the example of Mohammed and Fatima, let's say that they've got 4 grandchildren. Mohammed gives £250 to each grandchild and his wife does the same. So looking at it from just Mohammed's point of view, £250 a year for each grandchild comes to £1,000 in total for the 4 grandchildren. Over 20 years, so it'd be £20,000. Okay, the wife can do the same. That's £40,000. That's an inheritance tax saving of £16,000. So just the annual exemption and the additional gift allowance can allow you to save a lot of inheritance tax, and this is Sharia compliant because you're making lifetime gifts and at the same time reducing your inheritance tax.
Now, obviously, with all the different ways that you can, as I say, by gifting and exemptions and things like this, is it a complex thing to set up if somebody comes to visit you, Shakil, to put the wheels in motion, should we say?
Well, no. I mean, you don't need a solicitor to set this up for you. This is the reason I wanted to discuss it is that you can take advantage of these gifts yourselves. I know a lot of people use complex tax solutions to try and reduce inheritance tax, but they don't need to be complex. They're quite simple and you can do it yourself. Alternatively, you know, take advice from a solicitor and he will show you the different ways of how you can minimise your inheritance tax.
I think it's always, from my side of it, always peace of mind for me, when I've visited somebody like yourself, to obviously make sure that the I's are dotted and the T's are crossed, to make sure it's done properly. And with your wealth of experience, Shakil, I would feel more comfortable in front of you. But you say you can do it other ways. Now, is there any other way that you can gift from day-to-day earnings, week-to-week earnings? Is there any?
Yeah, there is a gift out of regular income. Now, in this, you can give as much as you want. There's no 7-year limit, which hopefully I'll explain in a few moments. So I'll give you, there's a number of conditions with gifts out of regular income. The first is it's a gift out of regular income, that's not capital. Second is that there must be some regularity to it. And the third condition is that it must not reduce your standard of living. Now, that's a bit of a mouthful, so maybe an example might help. Let's go back to, say, Mohammed. Mohammed is earning 15,000 and he's got £50,000 in the bank. He supplements his income by taking money from his bank, from his capital. Now, he won't be able to make a gift out of his regular income, primarily because it will reduce his standard of living. He's taking money out of his capital to survive. Now, the opposite scenario would be as if he was earning £50,000 and had only £5,000 in the bank. If his living expenses were £30,000, then he can make a gift out of regular income because he has £20,000 to play with because he's not going to reduce his standard of living.
It's a very, I suppose, fine line which you have to go down. Reducing your standard of living is that open to people's perceptions, or is there a guideline?
If you keep regular accounts in terms of what your average living costs are, and you show your income, then HMRC would be happy with that. There's got to be regularity. It's more than once a year, maybe 2 times or 3 times a year you can give it, but any amount you can give. So if you're earning millions, not that many people are, but if you're earning millions,
very lucky, yeah,
you can give a lot of money away. So that's another way of reducing your inheritance tax or reducing your estate.
Now, you mentioned the 7 years aspect at the beginning of this conversation. Is there a threshold that the 7 years covers?
Well, let's look at it this way. Any gift that you make, if you survive 7 years after making it, there's no inheritance tax to pay. So I'll give maybe another example, because I think for the layman it's probably easier.
Perfect, yeah.
If you have a valuable painting on your wall and that painting is worth £100,000, if you give it to your daughter but it's still hanging in your living room, that's not a potentially exempt transfer. However, if you give it to your daughter and it hangs in her bedroom, then it will be a potentially exempt transfer. And well, why is it called potentially exempt transfer? Because there's a possibility that there will be no inheritance tax to pay. And the way the rules work is that if you, from the moment you give the gift and you don't use it for your benefit, between 0 years and 3 years, if you die, that gift will be part of your estate on which inheritance tax is payable. However, if you live beyond 3 years, then inheritance tax is gradually reduced so that if you live beyond 7 years, there's no inheritance tax to pay.
Just a quick thing, I'm going to pick you up on this, because it's always those slight little points that count. You said if we give the painting to my daughter and she hangs it in her bedroom, does her bedroom have to be a separate building, or can it be her bedroom within the same house? Because the finite laws, I didn't know how it works.
You know, I've not come across that situation before, so I'm assuming that
if it's her bedroom, it's her bedroom.
You'd want to tick the I's for inheritance tax purposes with HMRC, and preferably it should be hanging in her bedroom in her house. Now, going back to what we talked about is giving a gift but then using it. That's called a gift with reservation of benefit. And therefore, if you die, regardless of whether you live 7 years or beyond 7 years after giving the gift, because you're still using it, it's part of your estate. It's only when you stop using it for your benefit, then the rules apply. Another example, I suppose, for everyday life was if you give a property to your son. Now, if he is living in it and you move to your house in Tuscany or in Spain, then that will be a potentially exempt gift if you live beyond 7 years. But if you don't and you continue to live in your property, then that's not potentially exempt gifts. So unless you are paying market rent to your son, it will form part of your estate if you die. And of course, on the income, if you are paying rent to your son, then he would have to pay income tax on the rent, and there's also capital gains tax possibly to take into account as well.
Is there a perfect age for somebody to set up this this inheritance tax ability to save money while you're alive? Is it, I mean, if you're 30, do you put it off to your 40? If you're 40, do you put it off to your 50?
I think it really comes down to what the value of your estate is, more than anything else. So if you have got a very large estate, then you can take steps to reduce it. Of course, there's different ways of reducing inheritance tax. You can use trust, which will be, I suppose, another topic because it's more complex, but lifetime gifts, potentially exempt transfers. Also, you can give gifts on marriage, which will then reduce your estate. If your son or daughter is getting married, you're allowed to give £5,000 to them. That's not just you, but it's also your wife. There's £10,000 in total. And you've got to give that gift before they're married or on the day of the marriage before the rings are exchanged. There's another gift that you can give to your grandchildren, which is £2,500 on when they're married, and £1,000 to a friend who may get married. So there's ways of reducing your inheritance tax, and if you take all of them or use all of them, you can really save a lot of inheritance tax, which is Sharia compliant.
And that's the benefit for everybody. You've worked long and hard in your life. You've done the job that you love, or sometimes in some cases the job that you have to do. It's a great thing to share that with your family in even more of a special way.
Well, absolutely. Nobody likes paying inheritance tax. You've worked all your life, you've paid your tax, and then on top of that, when you die, you have to pay more tax. It leaves a bad taste in the mouth.
And everything we've talked about, obviously, here on the show today is 100% normal, 100% legal. It's the thing that can be arranged quite easily. in my case, more easily sitting next to you and you guiding me through it. What do I, on day one that I want to make this happen so I can create a less inheritance tax, what forms do I need to fill in? How much do I need to pay to get something sorted out from the start?
Well, really, the first thing you need to do is work out what your estate is, because until you work out your estate, you can't really work out what your inheritance tax would be if you were to pass away tomorrow. So you would be looking to add up all your assets, take away all your liabilities, and that will give you a net figure of what you're worth, and then you'll be able to work out whether you are exempt from inheritance tax because your estate is below the 325,000, or you're above, and when you can start taking steps to reduce it.
In years to come, can I adapt my my figure? Because say my house is worth £400,000 today, and in 15 years' time it could be worth £700,000. So therefore my estate is worth more. Can I change the figure from the original figure that I put down as my net for inheritance tax?
Well, of course, because you'd be working it out every year what your estate is worth.
So you do it yearly?
Yeah, you do it. You know, when you have a will, does not mean that you lock it away and forget about it, because the law changes. You might get divorced. Your children might have children. There's any number of reasons why you would want to regularly review your will to make sure that it takes into account any change in circumstances, or also the law. I mean, you've got to remember that if I say in my will that I leave my Porsche car to my son, and then I don't review my will, and 2 years down the road I sell my Porsche car, my son doesn't get the proceeds of the Porsche car. That gift is void, that's gone. So you have to review your will to make sure that it's current, and you're saving inheritance tax, and everyone gets what gifts you give them.
So keep it always up to date, always relevant, and then you can maximise the inheritance tax benefits to you and your family as well.
Absolutely.
Well, Shaquille, as always, we've run out of time, but it's been a pleasure being with you for this season. Thank you very much, my friend.
Thank you.
Well, as I said, unfortunately, that's all we have time for. I'd like to thank Shaquille Bukhari Shah for being our guest and sharing his viewpoints and expertise on the topics discussed throughout this series. We would like to remind you that the views and opinions expressed in Legal Forum should be considered for informational purposes only and not case-specific legal advice. All topics are discussed in a generic nature, and it's important that you consult either with the CAB, Law Centre or a solicitor before relying on it. If you'd like to find out more about today's topic on inheritance tax, then please get in touch and email us at legalforum@islamchannel.tv. Well, thank you for watching, and join us next week for our last episode in the series. See you then. Assalamu alaikum.
This program is sponsored by Tilson Solicitors.